Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, Law Street Media, and Fastcase. I'm your host, Tom Hagee. So the Internal Revenue Service, that's a busy place, in case you didn't know. They publish a data book every year, keeping track of what they're doing and what they've accomplished. Last year, they collected nearly $5 trillion in gross taxes. They processed 263 million tax returns and other forms. And they issued more than $642 billion in tax refunds. And yet, some people still don't tip. Also last year, they served more than 58 million taxpayers who called into or visited IRS offices. Through irs.gov, they received over 1 billion visits, and taxpayers downloaded almost 455 million files. And in case you didn't think they cared, of the taxpayers who participated in the 2022 Comprehensive Taxpayer Attitude Survey, 84% said that it is not at all acceptable to cheat on your income taxes. I think I agree with that one. It leaves quite a few who don't think so. But still, 84% is pretty good. And nearly all, 93%, they believe it's your civic duty to pay their fair share of taxes. So, and then I don't know where that 7% falls. Finally, most taxpayers, 78%, are satisfied with their personal interactions with the IRS. I've had personal interactions with the IRS. I found them to be quite pleasant. But there are disputes. For example, the IRS closed more than 72,000 appeals last year, and the IRS Chief Counsel's office received more than 65,000 cases. Certainly some of these disputes, probably all, have to do with the rules. Rule number 1, pay your taxes. Rule number 2, don't lie to the IRS. This is not legal advice. I was just riffing there. The Administrative Procedure Act places specific requirements on federal agencies that are engaged in rulemaking. These are rules about rules that have the force and effect of law. Recently, the APA has become a focal point in tax litigation, due in large part to the Internal Revenue Service's record of refusing to comply with APA-mandated notice and comment requirement processes. Ultimately, APA challenges are important and may be necessary for a taxpayer to get to argue the merits of their case. You say, I didn't follow the rules. I say you didn't follow the rules. It's me kind of riffing again. But the reason I know even this much is because my guest, in his article for the Journal on Emerging Issues in Litigation, he wrote about challenges to the IRS, recent trends in tax litigation, and the future of APA challenges. He is Jeff Luechtefeld, attorney at Chamberlain Hrdlicka. Jeff is a tax controversy and litigation attorney with a strong technical tax background. He has a deep understanding of the inner workings of the IRS. Jeff advocates on behalf of clients in IRS examinations, appeals, and litigation. He previously led the regional tax controversy practice for a Big Four accounting firm. He started off with the IRS in their Office of Chief Counsel as a litigator. He eventually became a special trial attorney in the Large Business and International Division. Jeff received his JD from the University of Missouri and Columbia School of Law. Go Tigers. Can't spell Tigers without IRS. That's helpful to you, I know. So let's get to it. Here is my interview with Jeff Luechtefeld, partner at Chamberlain Hrdlicka. I hope you enjoy it. So Jeff, thanks for doing this with me today.
Oh, you're welcome, Tom. My pleasure.
Yeah, and thanks to a technical glitch, this is the second time we're doing it. So it's going to be even better. Let's get into it. So what requirements does the APA place on agencies in the federal government when engaged in rulemaking that has the force and effect of law?
Well, generally what's required is that an agency follow the notice and comment procedures that are set forth in the APA. And that basically requires that the agency publish in the Federal Register the terms or substance of the proposed rule. This then they're required to also allow interested parties to participate. That's generally either through submitting written comments and or a public hearing. And the agency is also required to consider the public's input and then incorporate that input into any final rule that they ultimately make. So that's the general notice and comment procedure.
Okay. So tell me about what's the IRS up to? According to the article, and I'll put a link to that in the show notes, that the IRS seems to believe it's exempt from some of these requirements, including the notice and comment requirement. Tell me about that.
Well, so for a very long time, the IRS has viewed most of its tax administration function as interpreting the statutes that Congress had put in place. In certain instances, Congress would give a specific delegation to the government to make a rule, and in those contexts, they always followed notice and comment proceeding because they believed they had to. But most of the other rulemakings that they made in the 6 or 7 volume set of Treasury regulations were believed to be under what is the general rulemaking authority, and the IRS generally believed that their regulations and their notices simply interpreted the rules that Congress had already put in place and were therefore exempt from the notice and comment rulemaking procedures. And that's persisted for some time, probably until probably until 2010, when the Mayo decision came out of the Supreme Court that basically said that the IRS is not necessarily special, and if it is making a legislative rule, regardless of its interpretation, that it would need to follow notice and comment. And really, somewhat to this day, or maybe not to this day, but to even more recently, the government has kind of continued to persist in its view that many of its regulations and certainly the notices the IRS issued are not legislative. And I think a lot of that's due to general government inertia. It's difficult for an agency as large as the IRS to change on a dime. And I think to some extent, the IRS has been recently caught by surprise by the willingness of the courts to question whether or not the IRS's views on its own rulemaking are correct. And I think there's also a kind of an inherently practical consideration here. There are thousands of pages of Treasury regulations, many of which did not go through a fully compliant notice and comment rulemaking. And the IRS, if the IRS hasn't provided notice and commenting for those regulations, and started doing so now, they'd have a massive problem with just the volume of rules that they would have to reissue. Also, the IRS has, up until very recently, not provided any notice and comment for the notices it issues. That would obviously be a problem for them as well. Those notices have significant effects on certain taxpayers.
Well, what's the IRS's current stance? What are things like with the agency today?
The IRS is still taking a very strong stance that they do not need to follow notice and comment in listing notices. They actually issued an announcement in April of this year indicating that they don't agree with many of the recent cases that was discussed in my article, and I expect that we'll continue to discuss on this podcast, and are indicate that they're still intending to defend prior listing notices issued without notice and comment, at least in circuits that haven't ruled against them.
Well, what's the impact of its? We're calling it their resistance to adhering to these rules. I guess that's what it is. It's just a resistance. They interpret things the way they interpret them. So what's the impact if they don't comply with these rules on taxpayers or anybody else?
Well, I mean, I think ultimately, if we take a step back, it's a good thing for a regulated group. And here the IRS is regulating taxpayers, right? Mm-hmm. To know why the regulator is taking a particular action. and to have some level of input into the rules that the agency is putting in place on those specific taxpayers. So when the IRS complies with the APA and fully follows the notice and comment procedures, I think that's a net positive for taxpayers. And so I think that also means that noncompliance is likely a net negative. Really, the only taxpayers that are going to benefit from the IRS's failure to comply with the APA are those who are able to use the APA, the IRS's noncompliance against them in litigation. But I mean, that's a very small segment of the population, and that means that whomever those folks are already in litigation with the government, which is hardly something most people would characterize as a win. It's probably good for tax litigators such as myself, who regularly fight with the government. But I don't think things that benefit tax litigators are generally good for tax administration.
Right. I think like it's the same probably for firemen, I'm sure if all this went away, you would find something else, some other gainful employment. So now you touched on this earlier, and it's not a distinction I've come across. A lot of this seems to hinge on the difference between a legislative rule and interpretive rule. So can you flesh that out a little bit more for me?
Yeah, so I think the distinction really turns on whether or not the rule that the agency is putting in place is creating a substantive rule as opposed to just interpreting a rule that Congress has already, made into law. So if we say that another way, is the rule creating some kind of new duty, or is it simply explaining or interpreting a duty that Congress already put in place? And if we take the IRS listing notices for an example, there's been two things that the courts have pointed to that show that these type of actions are legislative in nature. And that's reporting requirements. So you have to fill out forms that the IRS makes you fill out, and a penalty regime if you don't fill out the forms and follow the process that the IRS has put in place. And in the listed transaction world, both of these are fairly substantial. The reporting requirements require participants in and advisors to what the IRS calls reportable transactions to file either a Form 8886 or a Form 8918. Filing those forms is not they're not a postcard. They require substantial information. Like the Office of Management and Budget has to put an estimate on how long it's going to take somebody to fill out a form that they file with the government, and the time that somebody who has to file the Form 8886 would spend is in excess of 20 hours annually. And if you have to file multiples, obviously that adds up, and you're paying professional fees to do that, and sending the forms to the IRS, and all of those things. So it's not an insignificant amount of time. So the courts have looked at that as something that points to these being legislative rules, and probably more so the penalty regime that comes along with that. A failure to file that form, or a failure to even mail it to the correct places, could lead to a penalty of $200,000 per form. So that's obviously something else that the courts have looked at and has viewed those requirements as things that that notice is making rules that people have to comply with, and the failure to do so is very significant.
So what are listed transactions, and how do they relate to the IRS's work? Are they similar to transactions of interest, and why is it important to determine whether a transaction meets the definition of a listed transaction?
Listed transactions are generally the types of transactions that the IRS has identified as abusive in some way, shape, or form. So oftentimes, these are the types of transactions that the IRS views as quote unquote tax shelters. Something that is designed or engineered to achieve a tax savings that's beyond what the IRS believes Congress intended a particular tax law to achieve. Another aspect of most listed transactions, but maybe not all, and certainly not a requirement for listing, is a widespread marketing of the transaction. So conceptually, the listing of a widely marketed transaction is intended to stop or significantly slow the continued marketing of a transaction to the public. And you asked a little bit about transactions of interest. Mm-hmm. They're similar to listed transactions. When the IRS identifies something as a listed transaction, they've basically they're coming out and saying, we believe this to be abusive. Transactions of interest are things that have come across the IRS's radar, but the IRS and they think they might be abusive, but the IRS is less definitive in that belief. And so they want the reporting on that so they can make additional determinations of whether or not this is something that they need to spend significant amounts of enforcement action on.
So why is the being designated as a transaction of interest significant?
I think the major significance is the reporting requirement and the penalty regime we just talked about. I said that transactions of interest are kind of a junior version of a listed transaction, if you would. It's not something the IRS believes to be as abusive or hasn't made that determination, and that's somewhat reflected in the penalty regime. I said that listed transactions penalty regimes upwards of $200,000 for failure, whereas a transaction of interest is $50,000. So, I mean, it's not insignificant, but less.
Let's talk about how the courts are ruling. We talked about that before. So give us a lay of the land of what courts are having to say. I mean, you mentioned a Supreme Court decision.
Yeah, well, so coming out of Mayo in 2010, there was kind of a refocus on, I think, the tax dispute bar and others on focusing on the procedural aspects that the IRS has put in place. And a lot of this has really come to light in the listed transaction space. And probably the most significant cases that we've seen so far are cases coming out of the Sixth Circuit. So the Sixth Circuit, in a case called Mann Construction, ultimately held that a listing notice that related to a cash value life insurance transaction was invalid for failing to comply with the APA. And they went through the legislative versus interpretive analysis and looked at those things that we've already talked about. The time to comply with the information reporting requirement as well as the penalty regime, and found that the requirement that taxpayers that participated in that transaction be subjected to those regimes was invalid under the APA. The funny thing about Mann is, so Mann followed the CIC services case, which started before Mann, went all the way up to the Supreme Court, not on APA grounds, but on tax procedural grounds. CIC involved what's known as a small captive insurance arrangement, which was a transaction of interest. CIC Services sued to ask that the courts declare that it is not subject to the reporting and penalty regime. The district court ultimately dismissed the case on procedural grounds, the Anti-Injunction Act. And that went all the way up to the Supreme Court. The Supreme Court ruled that the Anti-Injunction Act didn't necessarily apply in this case and kicked it back down. So when CIC ultimately got its win, it was because the Sixth Circuit had already made its decision in Mann. Following Mann, a district court ultimately also invalidated the syndicated conservation easement listing notice 2017-10, following the Sixth Circuit's decision in Mann. That case was GBX Associates.
So that's the Sixth Circuit. What about decisions outside the Sixth Circuit?
Probably two other cases that are very front of mind to tax litigators. The United States Tax Court, which is a court of national jurisdiction, also invalidated the syndicated conservation easement listing notice. And that's significant because since tax court is a court of national jurisdiction, taxpayers that are litigating anywhere in the country in the tax court would benefit from that ruling. Another non-Sixth Circuit case, there's the case Green Rock that was decided by the Northern District of Alabama under very similar rationale to Mann. Green Rock is appealable to the 11th Circuit. The Department of Justice has appealed that decision. So everybody is watching that litigation to see if the 11th Circuit's going to follow the Sixth Circuit's decision in Mann. That's like I said, an ongoing and very hot topic.
You care to speculate as to the future of litigation in this area?
From a litigation perspective, I think we're going to see more and more of this type of litigation. I think one thing we've kind of seen is the current composition of the federal judiciary is willing to hold the IRS and for that matter, other federal agencies to task for blatant failures to follow the APA, like the Sixth Circuit found in Mann, but not engaging in notice and comment at all for these listing notices.
What about the IRS's behavior?
I think when the IRS makes some attempt to follow the APA, and they've done that in some of the cases that involve Treasury regulations, there's a split between the 11th and the Sixth Circuit, not on listing notices, but on regulations. But there seems to be more willingness for the courts to find compliance if the IRS makes some attempt to follow notice and comment. Okay. But for the listing notice cases, it seems apparent, at least to me, that the outright refusal to comply with the APA is not acceptable. I don't know that the 11th Circuit's going to get there in Green Rock, but I think the decision that the Sixth Circuit handed down in Mann is well-founded and makes a lot of sense. But because of kind of the current litigation posture, I think APA challenges to tax regulations and notices are going to remain prevalent over the short to medium term. I also think that the IRS is taking some notice of this. I don't think that. I know that the IRS is taking actions to avoid this type of litigation in the future. While I said earlier that they've issued an announcement that they're going to continue to defend the old listing notices that were issued without notice and comment, they have already reissued as proposed regulations subject to notice and comment rulemaking, the syndicated conservation easement rules. They issued those in December. And then, so those were the ones that have been, held invalid in the GBX case and the tax court, which was a case called Green Valley. I don't know that I mentioned that earlier. And then in April, they reissued the rules for the micro captives that were held invalid in Mann as proposed regulations subject to notice and comment. And just recently, they issued a new listing related to Malta pensions, a transaction that the government has kind of long made noise about. They put them on their dirty dozen list, but they haven't taken any real enforcement action until recently. And the action they took was to issue proposed regulations declaring them listed transactions. And so all of these show us that while the government might not like that the courts are kind of holding them to the APA, they are cognizant of it, and they're following what the courts are telling them to do, at least on a go-forward basis. I think it's a little harder for them to go back and reissue all of the listing notices as proposed regulations. I mean, a lot of the listing notices are 20 plus years old, and the transactions that they relate to have kind of long since died out. I don't know that we'll see them fix all of that, but it's an area where I think you're seeing the agency change its behavior because of the litigation.
Can you give a little more perspective, say, from kind of the position from the IRS as to why they are interpreting things the way they are?
Part of the IRS's position regarding interpretive versus is legislative is simply the breadth of the federal tax code, the laws that Congress passed. It's a significant body of law. I don't think that the IRS's views, at least early on, that it was simply interpreting Congress's intent, were totally off base. I think it's probably morphed over time. And I think the courts are generally more skeptical of administrative rulemaking this time.
So to wrap it up, what would you say from a practical perspective? What are the key takeaways?
Sure. I mean, I think from a takeaway perspective, where I kind of, why I see this as important. Like this is an important issue really for anybody who has a significant dispute with the IRS. Especially if there's some possibility that the IRS hasn't complied with the notice and comment procedures. What we're seeing is that the courts are already willing and able to check administrative overreach, either in the area of listing notices and in some instances, Treasury regulations themselves. But I also think it's very important for the parties to weigh the value of challenging a particular rulemaking, as parties to really any court cases would. They should compare like the usefulness of the relief they're asking for against the costs that are ultimately required to prevail. Some taxpayers, I think, absolutely have to make APA challenges because those challenges may be necessary for the taxpayer to even get to the point where they can argue the merits of their case. But winning on APA grounds doesn't necessarily by itself end the dispute. So it's a procedural aspect that oftentimes you may have to overcome, but it doesn't mean you win. It just means you, in a lot of cases, that you don't lose, which I guess is sometimes a win.
That's kind of a win. All right, Jeff, good. That's a good wrap up. So thank you very much once again for talking to me about this.
Yeah, no problem.
That concludes this episode of the Emerging Litigation Podcast. If you have any questions about anything you heard on the podcast or would like to participate, please write to me at editor@litigationconferences.com. The Emerging Litigation Podcast is a co-production of HB Litigation and Critical Legal Content, my companies, and Fastcase, and our friends at Law Street Media, David Nair, Editor-in-Chief. This is also the audio companion to the Journal on Emerging Issues in Litigation published by Fastcase, Full Court Press, Tom Hagee, Editor-in-Chief, Morgan Wright, Publisher. I'm your host, Tom Hagee. That's why I'm talking, and I don't know if it needs to be said, but this is not legal advice. Unless telling you it's not legal advice is legal advice, although I'd argue it's just plain common sense. Thanks for listening. Give us a rating, share with friends. See you on the next episode.